everyone, and welcome to this Federalist Society virtual event. My name is Emily Manning, and I'm Deputy Director of Strategic Partnerships with the Federalist Society. Today, we're excited to host a discussion titled, Is Patent Eligibility Doctrine in Need of Reform? We're joined today by Joseph Matal, Professor Kristen Osenga, the Honorable Randall R. Rader, and our moderator today is Michael K. Friedland. Michael is founding partner of Friedland Cianfrani LLP in Irvine, California. Michael has 3 decades of IP enforcement experience. He has represented clients in more than 200 intellectual property cases in state and federal courts throughout the country and before the Trademark Trials and Appeals Board. If you'd like to learn more about our speakers, their full bios can be viewed on our website. After our speakers give their opening remarks, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, thank you for joining us today, and Michael, the floor is yours.
Hi, good morning or good afternoon, everyone. We are very privileged today to have this discussion led by 3 just outstanding panelists who all bring slightly different perspectives to this topic as a result of differing but largely overlapping backgrounds. One of our panelists served as the Chief Judge of the Federal Circuit. 2 of our panelists have extensive teaching experience. 2 of our panelists have extensive legislative experience, and one of them has extensive patent office experience. I'm going to take a few moments to introduce them. You'll need to forgive me for abbreviating their biographies. It'll take me an entire hour to do all of their accomplishments justice. I'll begin with Chief Judge Rader. Judge Rader received his bachelor's degree from Brigham Young University, his law degree from George Washington. He served as a legislative assistant to U.S. Representative Virginia Smith, counsel to U.S. Representative Philip Crane. He was the legislative director of the U.S. House Ways and Means Committee. He was counsel to the U.S. Senate Judiciary Committee, where he was chief counsel or minority chief counsel for the Subcommittee on the Constitution and the Subcommittee on Patents, Trademarks, and Copyrights. In 1988, Judge Rader was nominated to the U.S. Court of Claims by President Reagan. In 1990, Judge Rader was nominated to the Federal Circuit by President George H.W. Bush. Judge Rader became Chief Judge of the Federal Circuit in 2010 and served on that court until 2014. Judge Rader has taught patent law and advanced IP courses at the University of Virginia, at Georgetown, and George Washington University. He's the co-author of one of the most widely used patent law textbooks, and we're extremely honored to have him here with us today. We're also very proud to have with us today Professor Kristen Osenga. Professor Osenga received her bachelor's degree in biomedical engineering from the University of Iowa, her master's degree in electrical engineering from Southern Illinois University, her law degree from the University of Illinois College of Law. After graduating, she practiced at Finnegan Henderson, where she prosecuted patents and litigated patents. She then clerked for Judge Richard Lynn of the U.S. Court of Appeals for the Federal Circuit. After clerking, she entered academia and has taught at Chicago Kent School of Law, Emory University School of Law, and William & Mary School of Law. She's been a professor at the University of Richmond since 2006, where she's the Austin E. Owen Research Scholar and Professor of Law, and she's also the Associate Dean for Academic Affairs. The professor is a frequent speaker and a prolific author, and we're extremely honored to have her with us here today as well. We're also honored to have with us Joseph Matal. Joseph received his bachelor's degree from Stanford University, his law degree from UC Berkeley. He clerked for the Alaska Supreme Court for Judge Rabinowitz, and he clerked on the Ninth Circuit for Judge Bill Canby. He practiced with Gibson, Dunn & Crutcher in Washington, D.C., then moved to Congress, where he served as policy director to U.S. Senator Peter Fitzgerald. He served as counsel to the U.S. Senate Judiciary Committee, and he served as the interim Undersecretary of Commerce and the director of the United States Patent and Trademark Office. At the USPTO, he also served as associate solicitor and acting solicitor. Mr. Matal became a partner at Haynes & Boone in Washington, D.C., and is currently the founder of his own intellectual property law firm, Clear IP LLC. We're extremely honored to have Mr. Matal and the other panelists with us here today. So our topic today is titled, "Is Patent Eligibility Doctrine in Need of Reform?" So speaking as someone who spends his day advising clients, or at least attempting to advise clients, the question isn't abstract or it's academic. A client can come to me with an invention. It could be brilliant, it could be revolutionary. It could create incredible efficiencies. It could disrupt the entire industry, or it could improve the treatment dramatically in chronic disease. But it involves a computer, and it doesn't make the computer work better. Or it involves using a formula to determine optimal dosage of a drug to treat a medical condition. So I'll look at the client and I'll sigh, because I don't need to know a lot more to have a really strong feeling where this is going. The district court's going to find the patent invalid under Section 101. The Federal Circuit is probably going to affirm, and the Supreme Court is probably going to deny cert. That issue arises as a result of recent Supreme Court decisions, primarily Mayo Collaborative versus Prometheus and Alice Corp versus CLS Bank International. Through these decisions, the court developed a two-step test to determine whether an invention is eligible for patent protection. In step one, the court has to determine whether the patent claim contains an abstract idea, an algorithm, a method of computation, or some other general principle. In step two, the court must determine whether the patent adds something extra that embodies an inventive concept. The something extra can't be generic, conventional, or obvious, like requiring a general purpose computer. Because it's a Federalist Society event, it's worth stepping back for a moment to consider where this fairly elaborate test comes from. It can't be seen in the Constitution. Article 1 sets forth the powers of Congress. And right there in Section 8, between the power to make post offices and the power to create courts inferior to the Supreme Court, the Constitution gives Congress the power to issue patents, or to create a patent system. And all it says is to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive rights to their respective writings and discoveries. That's it, just discoveries. So there's no two-part test there. So then we'll look to the statute that Congress actually enacted. That's 35 U.S.C. Section 101. And it says, whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefor, subject to the conditions and requirements of this title. So there's no two-part test there either. But it's the law, and it leaves my hypothetical client having to answer questions that are incredibly important to the client and important to the economy and the country as a whole. If the client already has an issued patent, is it worth investing in a lawsuit to enforce it? Or does the client simply allow it to be infringed? If a client doesn't have a patent, is it worth spending the time and money to get one? And most importantly, if the client hasn't yet invested the money to implement the invention, is it worth making the investment? Is it worth taking the risk? If the invention is as revolutionary as my client thinks it is, a tech giant or medical giant with unlimited resources could simply copy the idea. It raises numerous questions that we'll discuss today. Among them, in light of the Constitution and Section 1, is Alice even really good law? Is it good policy? And should it be changed? And there are proposals within Congress now precisely to do that. With that, I turn the microphone over to our panel of experts. I'll give the microphone first to Professor Osenga.
Thank you, Michael, and thank you for providing a background to some of the problem. I might cover a little bit in my remarks too as we go over it, because as a professor, I can't help but tell you how you should think about things. So I've been writing about patent eligibility since 2006, which I think makes me a little like prescient or psychic or something, because the real meat of the problem didn't really start till the early 2010s. But there were lingering problems even before then, in part because, as Michael pointed out, the judicially created exceptions came from nowhere except the courts. But what I want to talk about is how the law of patent eligibility has changed over the last 15 years. And then I really want to talk about and spend more of my time talking about the PERA, or the Patent Eligibility Restoration Act, or PERA, the pending bill that is intended to address the problem. Because I think, yes, an answer to the question that is the title of our webinar is Patent Eligibility Doctrine in need of reform. The answer is absolutely. And I'm going to go ahead and jump on the, and I think PERA is the way to go bandwagon with it. So, so with that, I will try to briefly tell you how I feel about this. So, 101, as Michael read to you, Section 101 of the Patent Act is really broad and really inclusive. And when the Supreme Court first started interpreting it back in the 1970s and 80s, or maybe not first interpreted it, but back in the 1970s and 80s, when they interpreted it, what they were saying is anything under the sun made by man, which is incredibly broad. And if we think about the great innovations that occurred in technology in the 1970s and 80s, when we get the introduction of the computing age and the introduction of biotechnology, that really broad reading of 101 really allowed the innovation economy to flourish. Okay, and so it was absolutely great. And during that time too, we didn't actually think about patent eligibility. I regularly tell my students, when I took patent law back in the late 90s, we didn't even cover 101. It wasn't a thing. I didn't even know it was a thing until things started popping up with business methods and what have you in the late 90s, early 2000s. So the exceptions to 101 didn't appear in the statute. They're judicially created. But between 1980 and about 2010, you know, it didn't become a problem. It became a problem because in 2010, the Supreme Court issued 4-ish cases, patent eligibility cases, that not only narrowed the patent eligibility standard, but also really kind of confused it. As Michael mentioned, the two-step test that came from Alice and Mayo makes it very confusing. We don't know what an inventive concept is. We don't know what directed to means. The Supreme Court has even told us they're not going to bother to tell us what an abstract idea is. So we have this test that applies to things that we don't know, in ways that we don't know how to apply, in ways that is becoming incredibly inconsistent. And as Michael says, it's really important, because what it's doing is it's causing clients to be confused. It's causing patent attorneys to be confused. It's causing lower courts to be confused. And so district court judges applying the two-step patent eligibility test are ending up with incredibly inconsistent results. Inventions that we have long thought were eligible for patenting, like machines, actual machines, things, manufactured objects, diagnostic methods, computer systems, in a number of cases have been found to be patent ineligible, not eligible for patenting, under 101. And so productive firms that are doing R&D in these areas where patents have long been part of the innovation ecosystem are now faced with the idea that maybe this isn't the best way to spend their money, because they may not be able to protect it because patents may not be able for them. And what we're seeing is that some of these firms are shifting to jurisdictions that have less ambiguous patent eligibility rules, such as China, Japan, and some European countries. Other firms are just jumping out of the R&D game altogether. And that's rather disappointing for somebody who really likes innovation, like me. So how can we fix this? I think we have to fix it legislatively. As I mentioned, when I started talking, I think the Patent Eligibility Restoration Act, or PERA, is a great first start. And so I'm going to talk a little bit more about that. So PERA seeks to return Section 101 eligibility to a broad and inclusive standard, while still acknowledging that not every invention should be appropriate for patenting. So it strikes a nice balance that doesn't leave the barn doors open, as I've heard some people be very concerned about fixing patent eligibility. We're going to end up with the barn doors being open. So the key features, as I see them with respect to PERA, is it eliminates these judicially created exceptions that Michael mentioned that the Supreme Court imposed on 101 eligibility, and it definitely gets rid of the two-step process for patent eligibility, the Alice-Mayo two-step. Instead, it provides a much easier to apply, clearer standard, which should make it easier for attorneys to advise their clients, make it easier for firms to decide where to invest, okay? And make it easier for courts to apply it without making a lot of mistakes. Despite claims to the contrary, PERA does not allow for any invention in the world or any discovery to be patented. It does not dismiss the inquiry into patent eligibility. It doesn't just erase 101 altogether. Everything is not going to be patentable if PERA is passed. And I'm going to give two reasons here why I think that this is a good thing. First, patent eligibility under Section 101 is just one of a number of tests that an invention has to pass in order to be patented. And that's something that oftentimes is getting lost in the discussion. They're like, oh, well, if we, alter 101 to make it more things be able to be eligible for patenting, everything will be patented, the world will come to an end. And that's not really the case, because even if it is eligible under Section 101 of the Patent Act, we still have 102, 103, and 112, which are rigorous requirements of patentability that are still going to be in play, even if we make 101 more expansive. And then the second thing I think is that PERA includes a number of exceptions that do protect us from having basic ideas and discoveries that are necessary from future research being able to be patented. So we still have this idea that we're not going to allow patent eligibility for things that are required for future innovation and research in a way that is more clear and more thoughtful than the judicially created exceptions that the Supreme Court applied. So I just want to run through those ideas really quickly in my next few minutes. Like I said, patent eligibility under Section 101 is just the first of many requirements. And one of the things that we've seen with patent eligibility, and one of the reasons why it's been confused over the last number of years, is that courts in particular have imported into the patent eligibility question a lot of questions that are already being answered in other areas of patent law. And so when we're talking about the Alice Mayo two-step, and we're talking about the inventive concept, and we're talking about preemption, and we're talking about all these things that the Supreme Court has kind of glommed into those 4 opinions that they developed the Alice Mayo two-step out of, what they did is they took a lot of pieces from here and there of other areas of patentability. And so we can take those out of the 101 patent eligibility analysis without harming patent law, because those things already existed. So 102 of the Patent Act requires the invention to be new. 103 of the Patent Act requires it to be not obvious. 112 requires it to be adequately described. And so rather than trying to clomb little tiny pieces of all of those tests into 101, let's just say, hey, 101 is a broad, inclusive standard. Let's let these other legislatively drafted requirements of patentability actually drive the ship, and let's let those be as rigorous as they're intended to be. That's where we're really going to be able to apply patent law in a way such that it's going to work to allow innovations through, but protect the right thing. The second thing that I want to say, and I know I'm running out of time, is that by putting the exceptions into 101 rather than letting them live in a judicially created space. And one of the nice features about the PERA bill is the idea that these exceptions are going to provide clearer guidance to ensure that basic knowledge isn't eligible for patenting, and not have these confusing Supreme Court ideas driving the ship there. So the specific exclusions are related to natural phenomenon and abstract ideas, but rather than having vague terms like natural phenomenon and abstract ideas, which is how the Supreme Court's exceptions to patent eligibility have been framed since the 1980s and before, these actually are more clearly delineated. So for example, the exclusion is for a mathematical formula not part of a useful invention. Well, that's good. That's helpful. That's much clearer than abstract idea, right? A mental process that is performed solely in the human mind, right? That gets to this idea of abstract as well, but it focuses the attention on what are we really worried about rather than this idea of abstract idea. And the reason this is important is because, as the Supreme Court itself has said and the Federal Circuit has said, almost every invention includes an abstract idea at some level. Many inventions include a natural phenomenon at some level, but where it's not the full invention, the thing that is being invented should probably be patent eligible. And it's hard to suss that out. And so one of the nice things, like I said, about the way that the PERA bill lays out the exclusions is it explains what we're really thinking about and worried about when we say things like abstract idea or natural phenomenon. And so with that, I'm going to go ahead and turn it back to Michael to let my fellow panelists tell me why I might be wrong.
Thank you, Professor. I'm going to go ahead and turn the microphone over now to Chief Judge Rader.
Thank you very much, Michael. And thank you, Professor Osenga. That was a marvelous presentation, and I would like to have said much of that myself. Let me reflect for just a moment on the fundamental errors which are evident in current patent eligibility policy. Probably the most important error is an abandonment of the statute. The statute gives the four categories that Mr. Friedland described to us earlier, and those did embrace vast areas of technology. And as long as those vast areas of technology produced some new, non-obvious, and fully disclosed invention, it was patentable, which is different from patent eligible, because eligibility was not seen by Thomas Jefferson, who wrote Section 101 and those four categories. It wasn't seen as an exclusion as much as a description of the breadth of patent eligible subject matter. Next, the question comes, well, if the Supreme Court abandoned the language written by Thomas Jefferson, of all people, in 1793, by the way, so it's been in existence for 200 years, where is stare decisis when you need it, right? But this 200-year-old language is abandoned. And what's it abandoned for? Well, the Supreme Court says there are three exceptions to patent eligible subject matter: natural laws, natural phenomena, and abstract ideas. Now, they're absolutely right that those three categories are not eligible, because not patentable, I should say, which is different from eligible, but they're not patentable because, of course, nobody can invent a natural law. Nobody can invent a natural phenomena. And an abstract idea was, in its original Supreme Court uses, defined very clearly as an unapplied theoretical principle, meaning that the test for eligibility was really, did you apply natural laws, natural phenomena, and theoretical ideas in a way that produced useful technology? And this is the rule that governed for up until 2010, when the Mayo opinion substituted these vague general categories, natural laws, phenomena, and abstract ideas, none of which was necessary, none of which was in the statute, for reasons we've already described. They said, well, this could be an entirely new examination to see if there are natural laws and natural phenomena and abstract ideas at work in inventions. Well, of course they're at work in inventions. They're at work in every invention. They're at work in every human enterprise and every endeavor. And so that became the problem. The breadth of the exceptions gave no usable standard for what would be excluded by them. And we've got vague ideas like, well, is the inventive concept providing us something more than conventional, usable, routine, well-known ideas, all of which are vague, standardless concepts. And that has rendered this whole area, as the professor eloquently described, as chaotic and confused and not predictable, not subject to any of the standards that should apply in statutory law, because this is not statutory law. This is an invention, ironic use of that term, I hope you understand, an invention of the court and not a productive one. Let me just, for the example, and I'll probably close here. Let me tell you what happened in the case that changed all this. Mayo. The invention is a personalized dosage regimen for the man-made drug thiopurine. Now, thiopurine is necessary to treat gastronomic distress, but not the kind of distress you treat with antacids. This is a severe condition which can result, if not treated, in death, as the stomach acid eats holes in places it shouldn't eat holes. Thiopurine solves that problem, but there's a problem with thiopurine. If you give too much, it exacerbates the situation. If you get too little, it is not a treatment regimen at all and doesn't help. And finding that personalized dose for every person is the invention. They do that by a blood test, which gives you certain readings, and based on those readings, you would adjust the dosage to get the proper treatment regimen. Well, where is the problem here? Well, the problem, according to the Supreme Court, is that this is a natural law. You should laugh at this point. I spent a little time telling you about the invention so that I could ask you this question. What's the natural law governing the dosage of a man-made drug named thiopurine that saves lives? Where's the natural law? By the way, that question had to be answered by the Supreme Court, and guess what? They didn't answer it. They said, well, human metabolism is subject to natural laws. Therefore, this is a natural law. Wow. Now you can see the problem that Mr. Friedland and Professor Osenga described for you. If something as specific as a personalized message dosage discovery invention is a natural law, what is not? Indeed, all inventions in the category of diagnosis and things like the Mayo invention have been struck down. And the effect of that has been very severe. I do a lot of work in this area. The money of investment for diagnostic research is no longer placed in the United States. It's placed in Europe, which has our prior statutory rule that if you're applying the natural law, it is eligible. Well, let me just conclude by saying that there's a lesson here. And the lesson is that when you stray from the statute and 200 years of very substantial and workable application of that law, and substitute your own ideas about what might be exceptions, ideas without standards at all, you're left with the confusion and chaos, which needs then legislative correction. And I endorse the bill that Professor Osenga discussed earlier. I'm left with a comment I made in a few opinions and still is valid. You know, when all else fails, consult the statute. The statute had it right. Where are we today, except in a mess without the statute? When all else fails, consult the statute. Thank you, Michael. Thank you, Professor.
Thank you so much, Judge. I'll turn the microphone now over to Mr. Matal.
Thanks, Michael. I kind of expected coming into this that my job would be to be the skunk at the garden party who disagrees with everyone. And I am prepared to say that I think about 90% of the Federal Circuit's decisions are perfectly sound and that PERA is a terrible idea. But I was struck by how much of Judge Rader said that I actually agree with. The way that the jurisprudence is dealing with natural laws in the field of diagnostics doesn't make sense. The court adopted this rule in Mayo, the Supreme Court, this isn't the Federal Circuit's fault, that for certain types of scientific discoveries, you basically have to assume away the discovery, otherwise you're claiming the discovery. And then once you get rid of the discovery, you ask, well, what's here that's inventive anymore? And it's, the answer is nothing. That is the test we apply now to medical diagnostics. And as a result, all medical diagnostics are ineligible. But that test isn't applied to any other area of science or engineering, even medical treatment. If you have an advance and you practically apply that advance, that's good enough. The fact that we have a deviant rule just for medical diagnostics and we treat all other fields of technology differently alone is a pretty good indicator that something's wrong, with this area of jurisprudence. But what's happening in medical diagnostics is terrible, but it's only a small percent of the overall jurisprudence. Overall, and I'd agree with Judge Rader and the professor that the courts could be more clear in the way they articulate the test, but in the end, about 70–80% of the cases just boil down to a test of, is this patent claiming an advance in technology, some kind of technological, improvement or breakthrough? And that can be a difficult question. Identifying is the human creativity here, the knowledge, does it reflect technology, or does it reflect what the Supreme Court's referred to as human activities? And human activities are things like business methods, things where you're really trying to, your advance isn't an advance in your understanding of the natural world, but rather an advance of your understanding of people. And the distinction that the law draws, I'd say, is analogous to the one that universities make between your science and engineering departments on the one hand, and your sociology departments and the humanities on the other. One of them studies the natural world, one of them studies, people and their intuitions into things. And that's basically the line that Alice drew, and that's what almost all of these cases come down to. So the second thing I'd have to disagree about is that this isn't grounded in the statute. I'll even one-up you on the statute. It's grounded in the U.S. Constitution. The Constitution says we grant patents for advance to promote the progress of science and the useful arts. Useful arts is kind of the 18th century way of saying technology, applied science. And so the Constitution itself told us this is what these things are supposed to be about. And then the statute Congress enacted under President Washington just limits patenting to machines, manufacturers, compositions of matter, all pretty physical, technological things. And then it adds the word process. It used to say the word art originally in the 52 Act. They kind of modernized the word art with process. The argument that things like business methods, should be eligible back when that argument was made 2 decades ago was that, well, business methods are a process, but it's a fairly conventional rule statutory interpretation, nocet or assosis, that you read one word to acquire the meaning of the things around them. And if machines, manufacturers, composition of matter are all about technology, that gives a limited meaning to process. Process isn't supposed to be this catch-all. It also is things in this technological context. So I'd argue there's a perfectly sound statutory basis as well for drawing this distinction between, again, things that claim some kind of improvement in technology and things that claim an improvement in basically understanding people or their motivations, what makes them buy something, or what's a better way to invest and corner the market, what's a better way of communicating information to people, or even entertaining them, games and things like that. All those things are out as human activities under this test. There's also a lot of debate about, well, aren't we, to do this test, you have to identify, before deciding, is this an advance in technology, you have to decide, what is the patent's advance? So the patent claims cite a computer, for example, and all these things, but how can I say it's a business method? Well, the courts developed various things to look at, look at the claims, what the specification describes as its advance, or what's just obviously already known in the prior art. And from that, you figure out, like, well, is this really are they claiming some improvement in the computer, or are there technology elements? Or does this really come down to this business method, this better way of targeting advertising to your audience, connecting people with what they want, or a better way of persuading them to buy things. And to do that test, you basically, you do have to do an overlapping inquiry with novelty and obviousness. You have to be willing to say, yes, although this patent recites a computer or the internet or communications technology, that's not really the invention. The invention, the claimed advance in this is in this other area, and this other area, just isn't eligible. In the 70s, they used to call this test the point of novelty test. Now we call it the focus of the claims test, but it all comes down to the same thing. Like, okay, the claims recite all these things, but what's actually the advance? And if you're going to designate certain subject matter as ineligible, as just, look, creativity in this area, in persuading people, selling them on stuff isn't eligible, then you have to do this analysis. You have to be willing to say, look, although there are computer elements in the claims, that's not the claimed advance. This person did not invent the computer. PERA has a provision that says it's just prohibited to look at any of the other issues, enablement or non-obviousness or anticipation. And I'd submit, if you have a requirement like that you're not allowed to consider whether the other features of a claim, were already known in the art, if they're not the advance, then you really can't enforce any subject matter restriction. Virtually every kind of invention these days is done on computers or with communications technology. And so it's easy to recite that in the claims. And if saying, by the way, this great idea of mine about how to persuade people to buy this or that, you do it on a computer. If reciting the computer in the claims is enough, and because you're not allowed to ask whether something was already known in the art, then you really can't enforce that bar on patenting human activities, on patenting the sales technique. There's just no other way around it. PERA also, PERA throws out that test and imposes, PERA basically gets rid of the test of, is there a claimed advance in technology? And instead asks, is this invention something that can't be practically performed without using technology? And so, as long as you're using communications technology or computers, whatnot, as part of your invention, if you really can't practically do the invention as it's envisioned without using those things, then you're eligible. What that does is it separates out the thing that makes you eligible from the thing that's actually your claimed advance. You can, as long as you need computers or cellular communications technology to carry out your invention, you don't have to make any actual improvement in that technology. You're just using it for your business method, and you're eligible. It's a test that's very different from anything that's ever been used in U.S. history. There's always been this, at least an implicit understanding that patents are limited to technology. And and one question I've always had is, why should that be the test? The fact that you're doing your business method, for example, at a scale where you need to communicate with people around the world. So of course you have to use modern communications technology. Okay, you're using this, but you didn't invent it. Patents are supposed to be about what you invented. Why should that be a basis for eligibility? The fact that you have so much information that you need to store it on a computer in order to carry out, again, like a business method, a sales technique, even a form of entertainment. Virtually all entertainment is, uses technology, right? Some kind of recording medium and broadcast medium. Why is the fact that you're using something that somebody else invented that you conceitedly don't make any improvement to, why should that make you eligible if we agree that patents are supposed to be about improvements in technology? So I haven't kept track of how much time I've used, Michael, so why don't we, I think I've done enough disagreeing with the judge and the professor, so why don't we open it up? So, Judge, since this is the Federalist Society, Judge, let me talk a little more actually about why I agree with you on Mayo. Mayo comes out of a deviation that crept into the Supreme Court's jurisprudence with the Funk Brothers decision in 1948. Funk Brothers was the seed case where they said, well, you figured out this way to get different seeds to work together, but once you assume away that scientific discovery, then what else is there? There's, the rest of it is obvious, once you assume that the science was already known. Since this is the Federalist Society, I'll just point out that Funk Brothers was written by William O. Douglas, one of the longest serving Supreme Court justices, pretty much the poster child for Supreme Court term limits, and generally known as one of the left-wing crazies on the court in the 20th century. That alone should be enough to get me at least halfway with persuading the audience that Funk Brothers was wrongly decided. But also Funk Brothers, by 1948, patent law, goes back to the origins of the Republic. You had pretty well established law that once you have a scientific discovery, as long as you're not claiming the discovery in the abstract, as long as you're practically applying it for some useful result, it's eligible. That was, black letter law in the case books, up through the 1930s. And then Douglas comes along with Funk Brothers and says, oh, you can't claim science. So if this invention uses a scientific improvement, assume away the discovery and then ask if anything else is obvious. And I'd submit that that's a test like peeling an onion. If every invention is based to some extent on science, all mechanical inventions are based on physics. Medicine and biochemistry, obviously the science is there. Once you assume away the science behind the discovery, yeah, of course everything is obvious because every advance in technology is based on science. So and I do agree, Mayo should be overruled. I love Justice Breyer. He's probably my favorite liberal on the Supreme Court, but he got it wrong in Mayo. He applied kind of a textbook version of Funk Brothers, and Funk Brothers is just wrong. If your patent is actually based on a scientific discovery and you're practically applying it, not just claiming the principle in the abstract, then it fully ought to be eligible. So I'll agree with the professor and the judge on that.
Well, thank you so much for the comments.
Thank you, Joseph.
Even if you may end up being the skunk at the garden party. Let me before we go to questions from the audience, let me give each of the panelists a chance to either react to their fellow panelist or ask a question of a fellow panelist.
Let me react very quickly to Joseph. By the way, those of us that have taught patent law for 35 years teach Funk Brothers as an obviousness opinion, not as an eligibility opinion. But you at one point kind of suggested that the problem was limited to diagnostics. Let me dispose of that with one recent case, which is in my casebook. You versus Apple. The invention, I should hold up my phone right now and you could see it. There's 3 cameras on the back of my phone that take 3 separate photographs at 3 separate settings, combine them to make a single, better photograph than can be taken by any single camera or any single lens. That was the invention. That was called abstract. What is abstract here? It's a camera. No, it's not a camera. It's 3 cameras. And it's 3 cameras combined in a way that had never been done before. Is that new? Yes. Nobody questions that. Is it obvious? I've never heard that questioned either, because it was very innovative, but somehow it was categorized as abstract. You can see the utter standardless application of eligibility principles in the U versus Apple decision. And you also see, we're not just talking about diagnostics here. We're talking about a great deal of software. We're talking about a great deal of high technology application, which really drives innovation in this modern age. That's my quick response, Michael.
Joseph, would you like a moment to respond?
Sure, yeah, I just had, yeah, unfortunately, we've gotten into this world where the word abstract is just used as ineligible, and all the different ineligibility tests are just are all fall under the rubric abstract. Before 2010, abstract only meant you're claiming the principle in the abstract. Now, abstract also means, oh, you're claiming a business method or some other human activity. And it also means that you're claiming an end result. The case that Judge Rader is talking about, UV Apple, it's a case that applies this very old Supreme Court case from the 1850s called O'Reilly v. Morse that condemned a patent for claiming the end result rather than the specific means by which you reach the result. It actually involved Professor Morse and the telegraph, and he did invent the telegraph, but he had this infamous 8th claim in his patent where he said, and by the way, I claim using magnetism by any means whatsoever to communicate. And the court said, you can't do that. You have to claim the specific means that gets you there. UV Apple was a case where, again, at some point the claims got a little too vague. This comes up in a lot of software patents too, where you have, yes, I use a computer and an input device and display and etc. And then when you get to, and I'll solve problem X. And then when you get to the end of the claims, it just the last part is a module that solves for X, with no description of how to get there.
Joseph, if that was true, you'd have a 112 problem, as you and I both know. It would have been vague, not properly claimed. That's a entirely different standard. That isn't what the court said. It said, oh no, it's abstract. We're not looking at anything else. That is an error, flat out, and it's hard to defend. Again, nice try on O'Reilly versus Morse, but that's an entirely different subject too.
Yeah, again, abstract just means you have a 101 problem these days. Unfortunately, it's not any more informative than that.
And maybe we need the PERA Act to describe what abstract is, right, Professor?
Yes. So I'm going to jump in now and get my 2 seconds to respond. Joseph, I agree with you for the first time, I think, ever. I also think Mayo should be overruled, so we can now be good friends. That's probably all I'm going to agree with you on. I just want to jump back to something that you were talking about in yours. With, we need to be looking for advances in technology. That's what's supposed to be patentable. We don't want to just add a computer to a sales pitch. PERA does in particular exclude specifically a lot of human behavior when it says it can't be done on a machine. So I just want to highlight that. But I think, and I also rarely do this, I'm also going to say, I actually think the Federal Circuit has done a really good job in one limited respect with obviousness and computers. I think they're like the leapfrog case and stuff like that, where the Federal Circuit has said, you know what, if you're just going to add a computer to do something that everybody's been doing all the time, all the ways, it's going to be obvious. I think that really protects that concern that you were highlighting, Joseph, was this idea of you've been doing it and now we're going to add a computer and we're going to say that's good and it's going to be patent eligible. Yeah, it's going to be patent eligible, but it's going to fail 103. And I'm not really as worried about that as you are. So, because I do think the Federal Circuit's obviousness has increased in rigor, whereas the other things have not. So.
I might ask a question that came from the audience. I'll direct this first probably to Joseph, but I'll ask others to chime in as well. So if I understood correctly, Joseph's position, it's that Article 1, Section 8 probably is the support for Alice and Mayo, and that defines a fairly narrow scope, a relatively narrower scope of patent eligibility than what others might agree with. In light of that, is it possible that PERA, if passed, would be held unconstitutional because it would broaden the scope of patently eligible subject matter beyond that which is granted by Article 1, Section 8?
Oh, it's an interesting question. The courts have never imposed constitutional limits on what can be patented. Congress has forced them to consider the issue in the copyright context with some of the extensions. The clause in the Constitution, it's stated as the purpose, etc. I don't know how far you could go in saying, well, because the purpose was only to promote progress of science and the useful arts, therefore you can't have patents where the innovation is a business method or some other human-focused activity. But I guess if Congress passes PERA, which by the way I think is very unlikely, that proposition might be tested. Again, PERA doesn't, it wouldn't make everything eligible. A pure business method that's just implemented in your head would still be ineligible. And just using technology alone wouldn't be enough. But if you can show that, I need to communicate at a speed or scale or store enough information accurately that I really need to use a computer, then you're eligible, even if your invention has nothing to do with that computer, if it's something you're just purchasing off the shelf. It would be, again, a pretty radical shift in how we've defined what kind of subject matter is eligible for a patent in the US and pretty much everywhere else too.
So one of the things that that Joseph said a moment ago is that he doubts that Congress will act on PERA. The professor, Judge, do you agree?
If you'd like me to go first, I keep a pretty close finger on this. It's certainly not going to happen in this Congress. My vote counts suggest that it's only got around a 30% approval in both houses at this point. However, each year it's growing. My experts on the subject, former Director Capos and former Chief Judge Michel, tell me that they think next Congress it'll have a 50-50 chance.
I defer to the good judge on his expertise there, but I also agree with Joseph that the chances of it passing right now are slim.
If it doesn't pass, or there's not some type of other legislative fix further down the line, what do we think the chances are that the Supreme Court, the Federal Circuit, are going to make modifications to the rules?
Never.
Well, I don't think I agree with that, Professor. The Supreme Court's changed. There is more attention to statutory construction. I think there's a chance that you would see Gorsuch and Alito perhaps taking up, and Roberts, by the way, who has written some good patent opinions, taking up another look in something like the Apple camera case or the American Axle case, which again dealt with hardware technology and its applications, not even software. But Supreme Court's a chance. An even better chance would be the Federal Circuit. The decisions in all three of the major 101 cases were heavily hedged by the Supreme Court. They gave invitations explicit to the Federal Circuit to ensure that the exceptions were not applied too broadly, because of course they would swallow or eviscerate patent law. They left areas completely undefined, like the definition of abstract itself, completely undone, inviting the Federal Circuit to step in and say, you know, that does mean unapplied. So there is adequate opportunity for the Federal Circuit to do its job, interpret the statute, which is what they've sworn to uphold, and the Constitution, Joseph. I'll let them interpret that too, to put this problem back in the bottle. So there are two chances. One, the Supreme Court may correct themselves. This is too glaring an error to sit out there for another decade. And the other chance is the Federal Circuit could realize the opportunity to clarify what up to now they have not done.
So I'll just add that we've had, I think last count, we've had 5 CVSGs in the last couple of years from the Supreme Court in 101 cases. So the court's still, you know, keeping an eye on this area of the law. Someone up there is still interested. I think they just haven't found the right case or the case.
And in the American Axle case, the Solicitor General answered that CVSG with a yes. You should take the case and correct it, which again may help gain momentum for the idea that this error needs correcting.
Yeah, the SG recommended taking up the interactive wearables case too, which the invention was the idea of when you play a song, tell people the name of the song at the same time. I'm not quite clear what the thinking was on taking that up as a vehicle. I don't think that would have gone well for the patent owner. But again, like the court's they're clearly interested. I don't think they're ever going to throw out the principle that patents have to claim an advance in technology as opposed to human activities. I don't think they're going to ever overrule O'Reilly v. Morse. You know, it's 170 years old at this point and been around a long time. I do think there's a good chance they'll eventually figure out, why do we have one rule for medical diagnostics and a completely different rule for every other field of technology, you know, even medical treatment? And why on earth are we still following a William O. Douglas opinion when it deviates from everything else? And, you know, there are always other little areas you can clean up. There's some inconsistencies in the Federal Circuit about how they deal with claims that claim technology for, information for its communicative content, you know, when you're kind of conveying information to people or targeting websites based on demographic information. There's always, you know, things to clean up. But to me, medical diagnostics is just such a glaring deviation. And again, when you have that one outlier that's treated differently from everything else for no apparent reason, it's, to me, that just makes it ripe for a correction.
I don't think anybody but you, Joseph, says that that's treated different from everything else. I think 95% of the patent bar would say you versus Apple is not a diagnostics case. American Axle is not a diagnostics case. American Garage Door Opener is not a diagnostics case. And I've only mentioned 3 or 4. Believe me, I could mention 150 if you had enough time to listen. Because
yeah, I'd agree. Those are
very heavily into reversing software-driven innovations.
I'd agree. There are other cases where things have been held ineligible, but I'd put UV Apple and American Axle pretty clearly applying the O'Reilly v. Morse rule. And again, I don't think they're going to throw out the rule that you can't just claim your end result. You have to claim the specific steps, you know, in your claim that get you to that result. You know, those pre-Civil War precedents, once they've made it this far, they tend not to get overruled, but we'll see, I guess.
They overruled the decisions in 101 that had been around since far longer than that, for at least 150 years. And by the way, that nobody says you versus Apple is an O'Reilly versus Morse case. I've never heard that except from you.
That's what I say. That's my reading of it.
Okay.
You know, it's
we all
debatable.
our own legal readings. I've only taught patent law for 35 years, and I have never heard anyone in the academic field say that. So
Well, you're
you
hearing
have
it,
a distinction, Joseph.
you're
and this-
hearing it today, Judge, but I'll reconsider and view your expertise.
Okay.
And this is precisely why we're so grateful for all of our panelists, including the skunks in the garden party. It's wonderful to have the opportunity to hear different points of view on these issues. And
Absolutely. I commend Joseph vastly, and he's made marvelous contributions, particularly when he was working on the American Invents Act. He's made marvelous contributions.
Thank you, Judge.
and all of you have in this discussion today. I see that that Emily is back on screen, which tells me that we're about out of time. So thank you very much, all of you, for just an absolutely terrific discussion. And I'll turn the microphone over to Emily.
On behalf of the Federalist Society, thank you all for joining us for this great discussion today. Thank you also to our audience for joining us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for tuning in, and we are adjourned.